ఈ ఏప్రిల్ 5వ తారీఖున అంటే శనివారం రోజు పొద్దున 10:30కి విజయవాడకి ప్రత్యేకంగా నేను వస్తున్నాను. విజయవాడలోని ఆంధ్ర లాయలా కాలేజ్లో సిఎస్బిఐఎస్ అకాడమీ పీసీఎం ప్రిలిమ్స్ కమ్ మెయిన్స్ బ్యాచ్ తర్వాత డిగ్రీ ప్లస్ సివిల్స్ ఎవరైతే గ్రాడ్యుయేషన్ చేస్తున్నారో లాయలా కాలేజ్లో కానీ బయట కానీ ఎవరైతే గ్రాడ్యుయేషన్ చేస్తున్నారో వాళ్ళందరి కోసం గ్రాడ్యుయేషన్ పోస్ట్ గ్రాడ్యుయేషన్ అందరి కోసం ఇంటిగ్రేటెడ్ కోర్స్ అనమాట. డిగ్రీ ప్లస్ సివిల్స్ కోర్స్ కూడా అక్కడ లాంచ్ చేస్తాం. దీనికి సంబంధించి అనేక సందేహాలు వస్తాయి. సివిల్స్ ఎగ్జామ్ ఎలా రాయాలి, ఎలా పాస్ అవ్వాలి, దీనికి సంబంధించి సివిల్సే కాదు రకరకాల కాంపిటేటివ్ ఎగ్జామ్స్ గ్రూప్ 1 గ్రూప్ 2 దీనికి సంబంధించి మీ సందేహాలు అడిగి తెలుసుకోవచ్చు. మీరు ఏప్రిల్ 5వ తారీఖున శనివారం పొద్దున 10:30కి ఎవరైతే రాష్ట్రం మొత్తం ఆంధ్రప్రదేశ్ కానీ తెలంగాణ కానీ ఇంటర్మీడియట్ పూర్తి చేశారో లేదా డిగ్రీ చదువుతూ సివిల్స్ ప్రిపేర్ అవుదాం అనుకుంటున్నారో అందరూ రావచ్చు, లేదా డిగ్రీ అయిపోయిన వాళ్ళు కూడా సివిల్స్ అక్కడ జాయిన్ అవ్వాలి అనుకున్న వాళ్ళు కూడా రావచ్చు అనమాట. ఏప్రిల్ 5వ తారీఖు పొద్దున 10:30కి విజయవాడలో నేను స్వయంగా ఆంధ్ర లాయలా కాలేజ్కి వస్తున్నాను. విజయవాడ ఆంధ్ర లాయలా కాలేజ్కి.
The Supreme Court of India has asked the Speaker of Telangana to expedite the resolution of petitions asking for the disqualification of 10 MLAs who conducted floor crossing or defection from Bharatiya Rashtra Samiti to Indian National Congress. In fact, the issue of defection is a very important issue in Indian electoral politics, and the anti-defection law has been passed in the Indian Parliament through the 52nd Constitutional Amendment Act, which added a new schedule to Indian Constitution, that is the 10th schedule. And under the provision of 10th schedule, if any member after getting elected changes the political party or changes his support from one political party to another political party, there is a chance for him to get disqualified, and the speaker is given the final authority in order to determine the petitions on disqualification. In fact, the 10th schedule has been introduced in Indian Constitution to protect the electoral mandate of people and public trust in the electoral system of India. And if you observe this, the main problem with the defection and the disqualification under defection is the final authority has been given to the speaker, and the speaker working as a quasi-judicial authority should resolve the issues of disqualification under defection. But the problem is, in most cases, the speaker, he belongs to the ruling party, and because of this reason, any defection which happens in favor of the ruling party is not being dealt in a fair and constitutional manner. In most cases, what is happening is the speaker is deliberately delaying the disqualification petitions, to the extent of 4.5 years, so that the very petition becomes invalid, because within 6 months the general elections are going to happen. And the Supreme Court has took cognizance of this issue on multiple occasions, including the recent issue. In fact, earlier the Supreme Court was not given any mandate, and the Anti-Defection Act very clearly stated that there could not be any judicial review on the decision of the speaker. But the Supreme Court, in a very famous case called the Q-Holohan case in 1992, said that as the speaker is working as a quasi-judicial body on the issues of defection, the Supreme Court has the right to review the decision of the speaker. In fact, the Supreme Court can check the decision of disqualification on malified intentions. It can also check it on the principles of natural justice. And the Supreme Court said that the speaker's decisions are subject to judicial review. And in a later case, which is called as 𝐃𝐨𝐰𝐧𝐥𝐨𝐚𝐝 versus Speaker of Manipur case, the Supreme Court has stated that the speaker should resolve the issues or the petitions of disqualification in a reasonable period. And now the issue is, with respect to the same reasonable period, the speaker has not, in fact, conducted any discussion, or he did not show any intent in order to disqualify the candidates whose disqualification on defection is pending in front of him. In fact, the Supreme Court said that the Supreme Court is not powerless in this matter, and it can even go to the extent of using Article 142, which provides the Supreme Court extraordinary powers in order to bring about complete justice in an issue, and it has asked the Speaker to resolve the issue in an expeditious manner. Otherwise, the Supreme Court is going to exercise its jurisdiction under 142 of Indian Constitution and bring about complete justice in the issue, which means that the speaker is now having a very, very clear direction that he has to resolve the issue in a time-bound manner. Otherwise, the Supreme Court is going to intervene in the issue. And even one more issue which the Supreme Court should take cognizance is the issue of merger of political parties. In multiple states across the country, what is happening is the legislative party of a political party is in fact merging with a 2/3 majority into a new party, and this also made mockery of the anti-defection provisions. Primarily because it's not the original party which is defecting, it is only the legislative party which is defecting and merging with one more party. And because of the merger, the candidates are not subjected to disqualification, which is also becoming a very big headache in case of anti-defection provisions. And we should wait for the Supreme Court clear-cut guidelines and a time-bound manner, 6 months, 1 year time period for resolution of petitions. Special provisions for this concept of merger should be developed by the Supreme Court. Only then more transparency and accountability will come into the Indian electoral process, and the anti-defection provision will not be misused anymore. Thank you.